This is Paul. Yeah. Now, let's give a little color to this. To admit, either expressly or implied by silence, yeah, that an opponent's allegations appear to be meritorious. In a common law pleading, a defendant's plea of confession avoidance had to give color to the plaintiff's allegations. Yeah. In the complaint or the plea would be fatally defective. Now see color. Oh, now, not getting any phone calls, the implied silence of me not being able to get the laws enforced. Yes. You know, after 3 years, it's obvious that you're trying to cover up the crime of issuing protection orders where there was no due process. It would have been better if I had heard from somebody years ago, but you're giving color to the color of law violations because of your refusal, to admit, either expressly or implied, by the silence, yes, that my allegations against you as an opponent appear to be meritorious. Yeah. Now, for every day that I said call me and just do a search of every email, that every person has gotten off of Facebook that has 509-599-1988 on it. Yes. Every time an IP address has downloaded, yes, or looked at the actual emails that have my phone number in it, yes, it adds to the color, yes, of the allegations. Now, somebody has my phone, don't they? Sheriff. Well, let's say you put your phone number in approximately a million emails because I've owned that phone for about a year and a half. Yeah. And then you put every email on Facebook so that every person could download it. And then I take the million emails that I've sent, yes, plus every IP address that has that phone number. I add them all together, and I would say it's a huge obstruction of justice. Now, I think you could get a decade for that. You're giving color, you're admitting, either expressly or implied, that by the silence of that phone not ringing, that my allegations appear to be meritorious. Yes. Now, I'm going to be the plaintiff in these lawsuits. Yes. It's going to be Paul C. Budnick suing all of those in law enforcement that would not dial that phone number. Pooch! Now, you might have been reading the actual emails. You might have seen the videos, 30,000 of them. And you thought, well, I better call it. But then, no, I'm not going to call it. It gives color to each and every lawsuit. Yes, it does. It adds to the green. Now, that phone should have rang 2.5 years ago when I emailed the Port Townsend, the Port Angeles, and the Sequim Police Departments that the petitioner did not sign it. I was not given any due process. And you issued it for 10 years. Now, we're looking forward, okay? 2.5 years later, November? Yes. 3 years later, ooh, it was November of 2015. 3 years and 3 months later, that every time right now, I'm just going to add some damages for the silence of the phone not ringing. Yes. Now, it is a form of torture. Yes, yes, yes. Now, Giglio versus United States, information relating to or suggesting an agreement between the prosecution of and any of its own witnesses, evidence that must be disclosed to the defense. Yes. Failure to disclose Giglio material, even negligent failure, violates the defendant's due process right. Yes. To any exculpatory information in the prosecution's possession. Yeah. I didn't get to see that email. Oh. Now, finding out that the civil rights coordinator is the wife of the coach, yes, does come into play with exactly why the athletic department had to have the three Budnick boys. Hmm. Let's say I sued you for not disclosing what is material because the Jefferson County Prosecuting Attorney's Office. negligent failure that violated my defendant's right to due process to any exculpatory information in the prosecution's possession. Yeah. The prosecution said under the penalty of perjury, yes, that he had an email that was sent to a third party, Pooch, at the petitioner's workplace. Yes, I never got a copy of it. Pooh! Why don't we get the Giglio material versus United States of America? The Giglio evidence. Oh, yes. Now there's the Gifts to a Minors Act, the Uniform Transfer to Minors. Yes. Could you get me all of the various accounts that you could participate in as a parent, where you could pay for college or university education for your children? Yes. And the actual underlying accounts, the Coverdale accounts? Yes, Coverdale accounts. And then the various parents throughout the United States that thought, well, we should set some money aside where you're going to pay for university. Now, let's say that you refuse to enforce the laws today and my son's graduated at 19 and a half years old. I know that would give a few extra years of growth on those underlying investments. See, I was a stockbroker. Yes, a financial consultant, a commodity trading advisor, and I was one of those insurance agents. Ooch, could you, Kyle? Ooch, just get me every tax deferred account of every student in every school where they graduated at 19 and a half years old. Now I know. It seems somewhat unfair to obligate students to graduate with the grouping that they should be in at the age that they should be in. But my wife is wanting them to be able to set aside some extra money so that by the time they actually graduate from my